All right, our second case this afternoon is case number 24-28, Carmona versus Stocking Management, LLC. Appellant's counsel, when you're ready. Did you want some help with the podium there? Do you want to raise it?
I think I can manage. Thank you.
Okay.
Good afternoon, Your Honor. May it please the court. Mike Weiner here from Tampa, Florida, on behalf of the appellant, along with my counsel, Mr. Skolko, who's watching online. We'd like to reserve 4 minutes for rebuttal, please. We are asking you to reverse the decision of the judge of compensation claims for three principal reasons, and to hold that under the particular facts of this case, that an employee is entitled to rely on the presumption that was discussed in the affordable plumbing case, that the employer has reported wages at least until he is allowed under IRS guidelines and rules to report those wages on his own. We assert that the judge erred for three principal reasons. Those include the fact that he did not properly apply the presumption that is set forth in affordable plumbing. Number two, that essentially it's created an impossible or act for the claimant to file wages or report his income to the IRS before the calendar year is up. And I want to discuss the facts of this case just for 30 or 40 seconds because I think they're very important. And last but not least, we also assert that the legislative intent behind Chapter 440 governs the application of this case and the outcome that we suggest. The facts that are particular to this case is that the claimant, we understand, was born in Nicaragua, came to the United States, and began working at Stocking Management in 2022. We know that on March 31st he has a compensable accident, and that as a result he meets all the other requirements for the payment of lost wages. He's not at max medical improvement. He's got restrictions which prevent his past relevant work. The judge of compensation claims determined that based on his actual earnings, which were paid to the claimant, actually directly deposited by the employer into the claimant's bank account, his average weekly wage would have been $803.06 per week, but for the application of Section 440.02. The claimant then is not receiving any benefits. He files two petitions, one in May, one in August, and the judge of compensation claims holds a hearing and renders an order in November of 2023. This chronology is very important. Why is it important? Because the employer, it is established as a matter of undisputed fact, did not do what they were supposed to do. The employer violated the law. The employer could have and should have reported his earnings to the federal government, to IRS. They didn't do that. So the statute, obviously, payment of wages, says that wages need to be reported. Does not say by whom. Affordable plumbing suggests, and we urge this court to hold, that there's a presumption that attaches that the employer has done that. But in this case, the nuance is that the claimant could not have done that himself by the time his final hearing occurred in his case, right? You can't file a tax return. He could not file a tax return for the calendar year of 2023 in November of 2023 while the year was still going on. The IRS doesn't accept that. We've referenced IRS publication number 509, which sets forth the calendar year for which employees are required to report, and it simply requires that employees have to do it by the 15th day of the fourth calendar month. The claimant was never given a chance to do that here. So we see a couple of doctrines, and we've talked about the impossibility of this.
What import, if any, do we take on the fact that claimant has never filed an income tax return? So there might be a presumption that the failure to file an income tax return suggests that they aren't reporting this income regardless of what the employer is doing.
Doesn't matter, quite frankly. What he did or didn't do in 2022, didn't do in 2021 is totally irrelevant to the outcome of this case. We know that, at least based on the record evidence, he didn't make enough money in those years to file income tax returns before. Right? The IRS has certain thresholds that if you're single, you have to file an income tax. We know that based on the record evidence that we have in the case. He never made enough money to do that. So I would submit to you that was a red herring argued by the appellees and found by the judge of compensation claims that has no input on the outcome or proper determination of this case.
So is your argument basically that this provision under the wage definition basically should just be ignored by courts? Because if I understand the rule that you're asking us to adopt, basically just ignore it because there's this presumption that it's always in effect.
I want to narrow what we're asking the court to determine in this case. We're not asking you to ignore the requirement. We're asking you to read into the requirement something that is consistent with what the IRS regulations contain. That is the when, right? Chapter 440 tells you simply the what. The claimant has to report. The when is dictated according to the Internal Revenue Service, right? So the claimant can't file his tax return in November of 2023 before the calendar year. So he can't report those wages. So the presumption should at least attach until such time as the claimant is given legally the opportunity through IRS regulations to report that income on his own.
Do we know much about when this presumption should or should not attach? I mean, here, for instance, we know that claimant didn't give any identification to the employer. Claimant didn't give the employer social security number, I guess taxpayer ID number. Plaintiff never filed an application for the job. So the employer basically had no information about this employee at all. And to the extent that a presumption, you would guess maybe a presumption should apply if I receive a paycheck stub every couple of weeks from my employer and it says there's been a deduction for federal tax purposes. Yeah, I think absolutely a presumption should attach that they're actually following through with what they should tell me. Under the conditions here where none of that is in play, should the presumption apply?
It should, and I'm going to tell you why. You've only looked at the part of the equation from the claimant. The other part is what the employer knew all along that he did not have the appropriate documentation. The employer knew all along that they were contracting to hire somebody and pay somebody wages who did not have the appropriate social security number or anything else, right? So the employer buried their head in the sand.
He knew that too, right?
Both sides knew that.
They both knew that.
They
right?
both knew that.
So to the extent there's a presumption, he also knows that he hasn't provided the appropriate information, that he's not authorized to work in the United States, and he doesn't anticipate that this income is going to be reported, right?
Well, I don't think that he knows that because, you've got somebody here who's obviously unsophisticated in the ways of what, requirements are under the United States law versus an employer who is at least should be presumed to know what the requirements are in terms of properly reporting taxes they pay because they're paying out salary. So, again, the employer under federal law was required to report those wages. They come to, to this equation here with unclean hands. And,
And both sides do, right?
And
I mean,
think
you
that-
would be in a lot stronger place if you were to file an application, employer had all of his information, his name,
Yeah.
his address, his social security number, and given him a check stub that said they were actually taking money out of his check.
Yeah, I can't.
That would give you a pretty
I
good
can't argue that. I mean, if I could go back and recreate the record, of course, I would do that, but we take the facts as they are in this case. And the facts as they are in this case are quite simply that the employer, presumptively should have known that it was supposed to report those earnings. They didn't do so, and the claimant should be allowed to rely on that presumption. I've got kind of three reasons why. We've talked about the impossibility of things. One of the things also is that, as I mentioned, the IRS regulations control the how you do it and when you do it in terms of reporting, right? The statute only says you have to report the wages, but you have to consider the IRS in terms of how and when. And the when does not occur until the end of the calendar year. So the claimant here has never been given the opportunity, right? So one of the cases or concepts this court has endorsed in prior cases is the law does not require a futile act, right? In this case, it would have been futile for the claimant to have filed taxes in 2023 before the end of the calendar year Can't do that. The other is the doctrine of impossibility. We know that applies to contract law, but we're seeking a similar extension of that doctrine of impossibility of performance as it pertains to a statutory requirement, right? The claimant is not able, it's impossible for him to file a tax return that the IRS will recognize as earnings that are being reported until the calendar year concludes. And, we also had but it was done belatedly today, and I apologize for that, but I've been sort of grasping for a way to better articulate this concept of impossibility that has been put on page 20 of the brief. And there's a Supreme Court case from 2011 called Pliva versus Minison that talks about where state and federal law conflict, the state law must give way. And we have a conflict here, right? We have an inherent tension between the requirements of reporting of income under state law in order to make the determination of your average weekly wage, and the federal law requirements would say you don't get to report that until the end of the calendar year. The case goes on to say that when the conflict exists and it's impossible to comply with both state and federal law, the federal law governs, right? So the federal law should govern here. And the question of impossibility, if a party could independently do what the state law requires of it. So the state law seems to require that the claimant file his taxes in 2023, right? That's what the definition of wages seems to imply. He cannot do that. And so under the doctrine of impossibility, we would suggest this is the proper outcome that Your Honor should reach in this case. Now, there's another reason why that I think is critical, and it's been discussed significantly in the brief.
Were we correct to call it a presumption? Because it sounds like you're arguing, no, this is actually a lot stronger. This isn't a presumption, this is a rule that it's on the employer and you can take it to the bank.
Well, no,
as opposed to calling it a presumption.
I think what we're asking for is simply a presumption that exists until the time when the employee is allowed legally under IRS regulations, which according to publication 509 is the 15th day of the fourth month of the following calendar year, right? He gets that presumption until that time. If the claimant does not report his earnings to the IRS by then he's SOL, out of luck, right? But that's what we're asking. And I want to just touch quickly upon the legislative intent, right? Because there's an inherent tension that exists between the reporting aspect and between what the legislature has told you how you are to construe the statute, right? So what do we know? We know that it is the intent of the workers' compensation law to assure the quick and efficient delivery of benefits to the injured worker. That same concept of giving benefits to the injured worker promptly is repeated again. It's twice. It is an overarching legislative edict that tells you how you should construe this reporting requirement. And if you fail to construe the reporting requirement in the manner that we suggest, and at least give the employee the opportunity before the 15th of April the following year to report those earnings, then you have frustrated the entire purpose of the prompt and efficient delivery of disability benefits
Would your case
to the
be
injured
stronger if
worker.
you would have supplemented the record along the way with his actual filing?
I don't know that I could, I don't know that I'm permitted really to supplement the record once the record is created with something that is created after the fact. I mean, it'd be one thing if this had happened during the proceedings and it was omitted by the reporter in certifying the record to Your Honors, but I don't know that the rules allow me to take some document that has been a piece of evidence that's newly crafted after the final hearing has already been rendered and say, here, look at this. So I don't know that the rules allow me to do that. I'll yield the rest of my time for rebuttal. Thank you.
Thank you. Police Counsel, proceed.
Thank you. May it please the court. My name is Allison McInvale, and I represent the Appley Employer Stocking Management, LLC, and its workers' compensation insurance carrier, Florida Citrus Business and Industries Fund. Your Honors, this is a very simple case about a very simple statute in 440.02 subsection 40. As to the definition of the word wages in establishment of an average weekly wage by demonstrating that income was both earned and reported for federal income tax purposes. What brings us here today is to determine whether the judge of compensation claims correctly applied the plain language of the statute, specifically the words reported for federal income tax purposes, and the prior decisions of this court, of which there have been many. What we should not be here for today are policy arguments presented by appellant, because those matters are better addressed to the legislature. This court has held in Fast Track Framing versus Caraballo that the phrase reported for federal income tax purposes is very clear and unambiguous. It conveys a clear and definite meaning. The legislature has given the judge of compensation claims a very simple test. Either income was reported for federal income tax purposes or it was not. That's all and nothing else. This court has already determined in 2020 in LSG Sky Chefs versus Zantea that the plain language of the general statutory definition limits wages to those that are both earned and reported and nothing else.
What shall we do with this idea of a presumption from the Affordable Plumbing case?
I disagree with appellant's reading of the Garcia-Lopez versus Affordable Plumbing case. I do not believe it created a legal presumption. When you read the holding of the case as a whole, the court was just elaborating on the finding in Fast Track Framing versus Caraballo that held that an employee must report for federal income tax purposes. The Garcia-Lopez versus Affordable Plumbing case simply stated that it need not only be the injured worker who has to report for federal income tax purposes to meet the definition of wages under the statute. The case notes that if an employer reports the earnings for federal income tax purposes, that would also satisfy the reporting element of the definition. I think that's as far as the Garcia-Lopez versus Affordable Plumbing case goes. An appellant seems to suggest that if there is a presumption of employer filing, then an employee can rely on that presumption that an employer made a reporting, and if there has been no reporting by an employer, then he's somehow excused from making a reporting himself. And in this case, under notions of estoppel, which clearly don't apply in this case.
What are the situations in which an employee could rightfully rely on a presumption that the employer was paying the taxes?
Well, I think as to this case, Your Honor, you raised a good point earlier today. I don't know how appellant could expect that a reporting would have been made because he knew he didn't have a Social Security number. He knew he didn't have a taxpayer identification number. He knew he wasn't documented legally to work here. So I think in this particular case, I don't think it follows that there would be a presumption that the employer paid withheld taxes. In fact, the appellant testified that he had had no conversations with the employer about taxes or anything of that sort. He testified that he didn't even know if taxes were being withheld by the employer. It's unreasonable for him to assume or presume any taxes were withheld. In fact, as Your Honor noted, how would the employer even do so without a Social Security number or taxpayer identification?
So is there any circumstance where an employee should be able to, maybe not this one, because he didn't have a Social Security number, is there any circumstance where they should be entitled to rely on the employer?
Well, I don't think there's a presumption in the law at all, to be honest with you, Your Honor. I don't think that's what the Garcia-Lopez versus Affordable Plumbing case stands for. But again, that would call upon a knowledge of the Internal Revenue Code as to whether reporting earnings are reportable or not reportable, or what an employer's tax status is, what the appellant's tax status is. We don't know. I don't think there is a presumption in the law, is my point.
I get a paycheck every week. Money's withheld for federal income taxes. I get injured, I find out that none of that was ever reported to the government. I'm just out of luck.
Then, according to the case law, the onus is on appellant to, or the injured worker, to make a reporting. I disagree with appellant's arguments that the appellant in this case would not have been able to do so.
Talk to
There
us about that. Why is it not impossible? Appellant makes I think leans into that argument quite a bit, that it's impossible. He could not possibly have made this reporting until the April 15th.
Yes. Well, first of all, appellant makes an argument that he did not have the minimum earnings with which to file an income tax return under the Internal Revenue Code. This court has made it very clear that they do not read the complexities of the Internal Revenue Code in Chapter 440 or as applicable to workers' compensation. The plain, clear, and unambiguous meaning of the statute does not provide for an exception or an exemption from the reporting requirements for any reason. If the legislature intended there to be such an exemption, such as for minimum earning requirements or timing, then it would have put it in the statute. It never intended the judge of compensation claims to undertake an analysis of the Internal Revenue Code to determine whether an injured worker falls into a category of reporting or not reporting. It improperly puts the judge of compensation claims in a position to decipher the U.S. tax code as to which this court has already disavowed, as outlined in cases such as the Renee Stone case, the Dubois case, the Casey Electric case, and the University of Florida versus Bowens case.
But all of those are different from, so it's different to say, hey, I don't have to report this. IRS says I don't have to. Okay, so then the answer is, well, you may not have to for the IRS purposes, but you do under the statute here, so do it anyways. But that's different from the argument, I think, that appellants, and I recognize they're making that argument also, but I think it's different from the argument that it's impossible to report it.
Yes, and much has been made about the timing of reporting in this case. But, Your Honors, this court has seen these exact same facts before. In the Centimark Corporation versus Gonzalez case, there were the same facts that we have here. An undocumented worker with no social security number in the United States for 2 years was paid cash with no tax withholdings. The date of accident in that case was February 23rd, 2007. The final hearing was held on January 14th, 2008. This court reversed the judge of compensation claims finding of an average weekly wage and found that that injured worker had made no showing that he had reported for federal income tax purposes. The timing of the hearing on or before any Internal Revenue Code filing deadlines, whatever those may be, had no bearing on the court's finding in the Centimark case. And there's no evidence that anything prohibited appellant in this case from filing any kind of filing. I'm not an expert in the Internal Revenue Code, neither is a judge of compensation claims, and I would hazard a guess that neither is this court or Mr. Quaresma, for even that matter. There's no evidence that he couldn't have made a quarterly reporting or a notice of payment of estimated taxes. Appellant also could have asked the judge of compensation claims for a continuance of the final hearing if it felt it needed to postpone for any reason to make a filing if that were appropriate, but appellant did not do so in this case. If the legislature intended for dates or deadlines to apply as to exceptions to reporting, then they could have done so in the statute. But this puts the judge of compensation claims in a position to decipher the U.S. tax code as to the timing of filings available, which this court, again, has already disavowed. It is not the role of this court to expand or modify the statute in the way that appellant seeks as to the timing. I disagree with the arguments about impossibility as well. I really don't think it matters. I also haven't heard what specific federal law appellant contends conflicts. Are we talking about the whole of the Internal Revenue Code? I haven't heard that argument here today. Appellant is offering his own opinion as to what the Internal Revenue Code requirements may or may not be as to his specific tax situation. And it all goes back to legislative intent. The legislature never intended to put such requirements into the statute. Judge of compensation claims does not have the power to analyze the Internal Revenue Code, and in fact, this court has disapproved of that. Is a judge of compensation claims now going to have to take evidence and make findings of fact about an injured worker's tax status, the amounts and types of income they may have, whether their income meets minimum thresholds, investment income, interest income, gambling income, who knows? Self-employment, whether or not they meet the minimums. Is a judge of compensation claims going to have to make conclusions of law under the Internal Revenue Code as to whether and when a party is supposed to file or report their taxes, what minimums apply, whether there are credits or refunds? Is a judge of compensation claims also going to have to make findings of fact and conclusions of law as to an employer's tax status, the timing of their payments and reporting? There's some problems with this, Your Honors. There would be an incentive for injured workers to conceal cash income if they thought it might make them ineligible to file a tax return, thus defrauding workers' compensation and the federal government. It would also create a system that rewards indemnity benefits to an injured worker for not reporting his income for federal income tax purposes. And second, the judge of compensation claims would be put in a position to analyze and apply the Internal Revenue Code in determining whether an injured worker's earnings meet the definition of wages. And the court has previously declined to expand the judge of compensation claims responsibilities. This court, for example, in Renee Stonework versus Gonzalez, adopted the position that there is no authority to support that the legislature intended that a judge of compensation claims decipher the U.S. tax code when determining whether an injured worker reported his earnings for the IRS. Furthermore, the judge of compensation claims is not a court of general jurisdiction, nor is a judge of compensation claims expected to apply subject matter beyond that specifically conferred by the statute. The judge of compensation claims is constrained only to application of the plain meaning of 440.02 subsection 40, not application and construction of the complexities of the Internal Revenue Code. The legislature made it very simple for a judge of compensation claims to find whether a reporting was made or not. It is a yes or it is a no, to make a determination as to whether earnings meet the definition of wages. Appellant proposes indemnity benefits should be paid on earnings not reported for federal income tax purposes. And that flies in the face of and is in direct conflict with 440.02 subsection 40 and would be an unfair outcome as to any other workers who did report their earnings for federal income tax purposes. Appellant argues that somehow appellant in this case was a poor and vulnerable member of society, but the record evidence does not support that. Mr. Quaresma is university educated. He's a mechanical engineer. He worked in the industrial mechanics for 15 years before he came to the United States. He testified he came to the United States for the purpose of providing his family with something better and sent all of his earnings home to Nicaragua. Again, these are policy arguments. The workers in Renee Stone and in the Garcia Lopez versus Affordable Plumbing cases were both undocumented without Social Security numbers, and both managed to file income tax returns. And in both of those cases, this court agreed that both had made a reporting for federal income tax purposes. Your Honors, this court should affirm the judge of compensation claims' order. The judge of compensation claims got it right. The judge of compensation claims correctly applied the plain, unambiguous meaning of 440.02 subsection 40, and as intended by the legislature, applied the very simple test of whether yes, a reporting was made or no, it was not. Here, competent substantial evidence supports that it was not reported. No reporting of earnings was made for federal income tax purposes, and therefore appellant's earnings do not meet the statutory definition of wages under the statute. To do otherwise would be to go beyond the powers of this court. It would be a matter for the legislature to add, expand, or modify the statute in any way. The judge also got it right when he found no competent substantial evidence that the appellant relied on any misrepresentation or presumption, as they argue here today, and changed his position to his detriment. There is no competent substantial evidence that the employer made any misrepresentations, that the appellant relied on any of those misrepresentations or even the presumption, and there's no record evidence the appellant changed his position based on any misrepresentation or presumption. Estoppel does not apply in this case, Your Honors. And finally, the judge of compensation claims did not abuse his discretion in declining to apply the unclean hands doctrine, particularly in light of the fact that there was no competent substantial evidence to support application of the doctrine. There was no trickery or concealment or unconscionable conduct here. Therefore, this court must affirm. Thank you.
Thank you, Ms. McInville. If you could address the Cinemark versus Gonzalez case that Eppley argues is on all fours.
In particular, with regard to which point, Your Honor?
In particular, that Eppley argued that it was on all fours with this case and cited it 4 times in her brief.
Yeah, I don't think it is. First of all, they never reached the critical issue that we're here for in this case, right? They mentioned nothing at all of the impossibility of the injured worker to have reported his earnings in that case. So that was an issue that wasn't even considered in that case. While there may be some similar features in terms of Hispanic workers who were undocumented, that's about where it ends. So I don't really see in any fashion how that case controls the outcome of this case. What does control the outcome of this case, we'll agree on this point, right? Plain language of the statute. It requires simply that wages earned and reported for federal income tax purposes. Here's where the judge went wrong. He added a requirement that those wages had to be reported in the same calendar year as the final hearing or before the final hearing. Again, the legislature does not say when they have to be reported. And again, it was impossible for the injured worker here to have reported those earnings, right? It would have been a futile act. We're not asking for policy arguments, right? What we're asking Your Honors to do is consider the plain language of the statute that the legislature contains no direction whatsoever as to when the earnings have to be reported. And it only gives you reference for federal income tax. Well, that reference that it gives you for federal income tax should direct you to look at what the IRS code says about when it has to be done, right? This is not about public policy. This is about legislative intent. And the statute is very, very clear that the statute is to be construed in a way, all right, this is an edict upon you as members of this court, that you construe this law in a way that assures the quick and efficient and prompt delivery of benefits to the injured worker. It doesn't say it once that you do that, it says it twice, because it's that important, it's that foundational. And when you look at that legislative edict and you look at simply what the statute requires with no guidance as to when it must be reported, I would submit to you the alternatives are 2. Number 1, we let the injured worker go without any benefits until he can file his report his earnings for the following year, or we allow the presumption to apply, as we've argued, that the injured worker gets the presumption the employer reported those earnings until such time as he is allowed under federal law to report that income the following year by April 15th. So, Your Honors, we would respectfully ask that you reverse and remand consistent with what the request for relief that was contained in our brief at the conclusion section. Thank you.
Thank you very much. All right, that concludes our OA docket for this afternoon. We're adjourned.